Okay na po.
Okay na? Sure? Record ko na.
Yes, sir, na-record.
Okay. So, welcome back, guys. So, after 2 weeks na wala tayong meeting, we're on our last topic for the finals. Narinig niyo ako, okay lang? We're done with the first topic, which is credit transactions. So, medyo mahaba yun compared dito. So, bulk ng questions sa final exam is sa credit transactions. No? Pero madami din naman dito. Kasi over 100 yung final exam. No? So, I'm hoping na mabasa niyo yun kasi next week around Tuesday or Wednesday quiz on credit transactions. Okay? Ha? Yes. Okay? Wednesday or Tuesday. Whatever your time permits. Credit transactions only. Okay? After that, we'll continue with this and then hopefully last meeting natin. Ha? Hanggang kailan daw ang final exam ninyo?
Yes, 19 lang eh. Meron lang study sa portal, 19 lang.
Hindi kasali ang 18 holiday. Yung release mo academic calendar hindi kasali ang 18.
17.
17, 19, 20.
Sunday ang 18.
Close.
Charis.
Oo nga, pero 16 ano lang start. 16 ang start and
16 lang start. Buti na lang tinuloy ko kasi akala ko konti na lang ang time ninyo. Wala ko lang 19 to 23. Anong day ang yung loan nyo?
last day ko.
Anong day yun?
Monday ko.
Wala. Okay. We have to bear with the noise kasi sila din naman, they bear with your noise naman before. No? So, it's give and take na lang. So, credit transactions, I hope okay kayo dun ha. May questions ba kayo sa credit transactions? Did you watch it? No? Okay, sige. Nonetheless, we'll proceed with the Intellectual Property Code of the Philippines. So, do you have any working knowledge of Intellectual Property Code of the Philippines? May basic idea ba kayo? Or general notion when you hear the words Intellectual Property Code? Or Intellectual Property? Anong pumapasok sa isip nyo?
Ano po? Yung patent po. May time po kasi na...
Siyempre, aside sa
May
nakasulat
time po
dito.
kasi na nagsulat po ng Kim yung si Mami. Tapos
Nagsulat ng
Kim po.
him.
Opo.
Tawag him.
Former tourism officer po kasi siya ng isang LGU. Tapos sumulat po
Saan
siya ng
LGU?
Bilakan po.
Okay.
Itinatry niya pang i-offer pero hindi nila tinanggap nung ino-offer niya. Ang ginawa niya po, ipinapatent niya. Ngayon po kapag pagagamit ng bibilakan niya, magbabayad po ako.
Oh, ginamit ng dibilikan? Ginamit ng dibilikan.
Opo.
Okay.
Tapos may binayaran po yung
Ang tawag doon is copyright,
Koreans.
hindi patent. Copyright, yung mga artistic creations, no? Like yung hymn yung kanta, di ba? Okay, so kung gagawa ka ng point ng kanta, ayan, copyright. Basta artistic creations. When we talk about patents, kapag patent, ano naman? Yeah, sabi ko nga, aside dun sa topic, in general knowledge siya sana, no? Sige. So, inventions, no? Patent. Okay, hindi copyright. So, magkakaiba sila. Okay, and especially, of course, trademarks. So, meron na ditong nakabasa in advance. So, useless na tanongin ko ang personal opinion kasi hindi niya na ibibigay, ha? personal opinion. When you say trademark, just like dito, anong trademark na makikita nyo? Logo, the Apple logo, no? That's a mark or a trademark. Okay? So, yun yung pag-uusapan lang natin. The Intellectual Property Code of the Philippines contains about 200 plus sections, I think. No? But we are going to discuss a few sections only kasi hindi naman natin kailangan aralin over to cover. Okay? Mismo, pati kami sa law school, hindi namin inaral. Okay? So, yung important lang na aralin yung i-discuss natin about intellectual property code. Okay? Let's proceed. So first, under intellectual property code, we'll talk about first section 3, which is international conventions and reciprocity. Okay? Any person who is a national or who is domiciled or has a real and effective industrial establishment in the country, which is a party to any convention, treaty, or agreement relating to intellectual property rights or the repression of unfair competition, to which the Philippines is also a party, extends reciprocal rights to nationals of the Philippines by law, shall be entitled to benefits to the extent, hirap pakipagpuntit sa ano, necessary to give effect to any provision of such convention, treaty, or reciprocal law, in addition to the rights to which any owner of an intellectual property rights is otherwise entitled by this act. Oh my God. Okay, so what do we mean when we say international conventions and reciprocity? So, masyado kasing malawak ang concept ng business that it, anong tawag ko doon? It goes over the boundaries of every country. No? Let's say, for example, yung business ni Apple, yung business ni Nike, hindi mo lang naman siya mahanap sa USA lang. No? It operates, naaabot niya pati ang Philippines, ang Asia. Okay? So, yun yung ibig sabihin niya because as long as a country is a party to any convention, treaty, or agreement, when we say convention or treaty, kung sa parties, mayroong contract of sale, mayroong mga contracts, ito ang contract sa ating mga hindi parties. Parties ang nag-enter pero countries ang parties, hindi tao. Okay? So kung signatory si Philippines sa isang convention, treaty, or agreement relating to intellectual property, okay, bound sila by that convention or treaty. Okay, an example of that is the Paris Convention. Ito yung unang convention on intellectual property rights. Meaning, even if hindi registered si Nike, si Adidas, si Apple dito sa Philippines, under the Philippine law, okay, as long as party sila sa Paris Convention, recognize ang rights nila under the Philippine law. Okay? Kasi matututunan nyo later on na ang copyright, ang trademark, ang patent, i-register mo sa Intellectual Property Office. Okay? Dito sa Pilipinas. Pero yung brands nila Adidas, nila Apple, you cannot find it under there. Kahit hindi sila mag-register dyan, recognize yung rights nila. Okay, you will understand that more later. Okay, you understand? Intindihan ba?
Yes.
Okay. Ito naman, tapos na yan? Hindi pa. Okay, now let's go to the definitions. No? Under the law, intellectual property rights was defined as consisting of, so ito yung all the intellectual property rights that can be found under this law. Now, we have the copyright and related rights, we have trademarks and service marks, geographic indications, industrial designs, patents, layout designs, and protection of undisclosed information or clips. These are all intellectual property rights, but we will not discuss everything. No? We will focus on copyright, trademarks, and patents. Kasi yan yung usually na nagagamit. No? Yung sa iba kasi, hindi naman sila masyado nalalaan. Okay? So when we talk about trademark, o yung TM na nakikita niyo sa logo, okay, try niyo magtingin-tingin, yan yung trademark na sinasabi. A trademark is any visible sign capable of distinguishing goods. When we're talking about goods, we refer to trademark, or services, which we refer to as service mark of an enterprise, and shall include a stamp or mark container of goods. It means the name or designation identifying or distinguishing an enterprise. So, gaya ng, let's say for example, under the illustration, you can see on the whiteboard. Okay? So here, trademark ni McDonald's, yes, this one, di ba? Ayan, meron siyang sign. Ang tendency kasi, excuse me, ang tendency kasi sa trademarks, no, under intellectual property rights, is kapag hindi mo sisilect yung rights mo, pwede yung gayahin ng iba, pwede yung abusuhin ng iba, for what, no? To gain profit, no? Imagine this one. Dinaya. Okay?
Hindi naman dapat hard down.
Let's say for example, attorney, paano kung magkaiba sila ng business? No? Can it still have an effect on McDonald's? Yes. No? Let's say for example, hindi ko kasi alam itong McDonald's. No? Let's say for example, nagbibenta siya ng toothpaste. There's a tendency na baka akala nila itong toothpaste na to ay galing kay McDonald's. So it may result into dilution, or yung tawag nating trademark dilution. Parang nababawasan yung value even though they don't offer the same goods, the same services, no? Yun kasi yung under this case, may tinatawag tayong infringement. No? There could exist in what we call infringement. Infringement can be committed either on a copyright, on a trademark, or on a patent. So, ang importante lang is, as we will discuss later, okay, meron tayong factors to determine whether there is a copyright infringement, trademark infringement, or patent infringement. Okay, for now, we'll stick with the definition of a trademark. A copyright naman is confined to literary and artistic works which are original intellectual creations in the literary and artistic domain, protected from the moment of their creation. So yan yung copyright. So hindi siya invention, not necessarily creating something, but creating something out of literary and artistic works. Take note, it says here that it is protected from the time of their creation. So whether you register it or not, that is protected. But if you want to enforce your right, better you register it. Okay? Kasi product lahat ito ng, para maging mas simple, product lahat ito ng utak ng tao. Okay, ito yung mas sinasabing utak natin, utak ng tao. Lahat yan, product ng utak ng tao. And therefore, we need to protect those rights para na rin siyang ginawa mong property. No? Next is patent. A patentable invention refers to any technical solution of a problem in any field of human activity which is new, involves an inventive step, and is industrially applicable. So it is a solution to a problem. So merong problema, you offer a solution in any field of human activity basta siya ay bago. So kung existing na yan, matagal nang nag-exist yan, hindi yan pwede as patent. Okay? Kung it involves an inventive step, it must involve an inventive step. Okay? And it must be industrially applicable. Meaning, pwedeng gamitin ng tao para sa masa, para sa tao. Okay? So, ang idea is, if you invented something that will solve any problem in any field of human activity, mas maganda na i-patent mo. Why? Not only to secure your rights, para makatulong ka din sa iba, di ba? You imagine if yung inventions like electric fan, like yung TV were never patented, no? Sinikreto. Imagine, until this day, baka hindi pa natin yan na-improve. Kasi, itong creations na ito, nagsimula yan, hindi naman ganyan eh. Ibang invention, nag-improve lang. Okay? That is one of the good purposes of intellectual property law is it encourages invention and at the same time innovation. No? Imagine if yung invention na cellphone nag-stick kayo dun sa keypad. No? Imagine if hindi tayo nag-transition hanggang sa mga touchscreen, di ba? Imagine. No? So lahat yan, mas maganda if merong patent not only to secure your rights but also to promote further innovations sa product para meron ka pang improvement. Yung sasakyan, di naman nagsimula yan na merong touchscreen. Hindi naman yan nagsimula na merong mga emergency sensors, di ba? Nagsimula yan dati, manual, walang sensors, walang touchscreen. Pero ngayon, tignan mo yung development. So yun yung impact ng pagpapatent ng isang invention. Okay? Questions? So yun yung focus natin ha. We are going to focus with patent, trademark, and copyright. Okay? Ang wallet ba? Patent ba yan? Or trademark? Or copyright? Patent. Kasi meron akong kaibigan. Ha? Kaibigan ko ba yun? Nagpa-register siya ng patent. Ang invention niya is pitaka. Pero yung pitaka na yun, galing sa skin ng no? Hindi. Meron na yun yung sa crocodile. Ahas, meron na yun. Ito kasi, itong kaibigan ko, nagtatrabaho siya sa hospital.
Tao?
Hindi tao. Sa hospital na, alam mo yung nagtutulik? Siyempre, kapag tinuli ka,
Na matatanggal na skin.
yung excess skin.
Yun yung ginamit niya sa sir?
Ang ginamit niya daw, yun daw ang ginamit niya.
Trademark din, sir. Akong yung design dati na.
Oh, ang pumunta daw siya sa IPO. Ano yan? Anong paparegister mo? Sabi niya. Wallet, sabi niya. Meron na yan, ang dami ng ganyan, iba't ibang klase pa nga.
Sinabi sa IPO.
Yun lang, sabi niya, iba't ibang klase. Hindi, iba ito, sabi niya. Maganda ito, sabi niya. Bakit? Himasin mo maging maleta. So hindi mas siya naging maleta, lumaki.
Alam ako.
Why? Kasi dun sa...
Joke pala yun. Akala ko totoo.
Ay, joke.
It's a joke, guys. Masyado kayo seryoso. Hindi, himasin mo daw lang. Laki yung wallet. Magiging maleta. Oy,
Nuggets.
ilang taon na kayo?
Nuggets.
Ilang,
Habang hindi.
Ilang taon na kayo? 19 year old and up there. Okay, next. Definitions. We'll stick with definitions. Kindly take note of the definition on technology transfer arrangements. These are contracts. When we're talking about arrangements, these are contracts or agreements involving the transfer of systematic knowledge for the manufacture of a product, application of a process, or rendering of service, including management contracts and the transfer, assignment, or licensing of all forms of intellectual property rights. So take note of the definition of technology transfer arrangements. Chapter 2, patentability. Okay? First, let's talk about patents. So, as we have defined earlier, a patent or a patentable invention is any technical solution of a problem in any field of human activity which is new, involves an inventive step, and is industrially applicable. It may be a product, a process, or an improvement of a product or an improvement of a process. So take note of the definition and the keywords involving patents or patentable invention. So it must be a solution to a problem in any field of human activity. It must be new, involves an inventive step, and industrially applicable. So what is the purpose? Actually, sinabi ko na ito kanina, no? The first one is to foster and reward inventions. No? Lalo na when we talk about patents, they are industrially applicable, meaning magbe-benefit ang tao. Okay, it is for the benefit of humankind precisely because it is a solution to a problem in any field of human activity. It promotes disclosures of inventions to stimulate innovation and to permit the public to practice the invention after expiration. So what does it mean? As I have said kanina, no, by registering your patents or your invention, you could stimulate innovation. So, hindi lang yung mag-stick ka sa concept ng original patent or invention, there could be innovations that could further improve the invention. Kung ano man yun, no? So, let's say, for example, gaya ng cellphone, no? From a keypad, diba, yung folded pa na keypad, to a touchscreen, okay? Smartphone, touchscreen, no? There are innovations made. And hindi lang isang company ang gumagawa. Hindi na lang isang company ang nag-innovate. Diba? Why? Kasi the public is committed to practice the invention after expiration. No? Woo! Okay, so that is the second purpose. The third, there are expiration kasi in every copyright, trademark, or patent by limitation.
Ano ba ibig sabihin?
Meaning, after, let's say for example, 20 years, for patent, the normal is 20 years. So after 20 years, for public use na yung invention mo. Meaning, anyone can invent what you just did. They can copy what you just did, and they can introduce innovation.
Sir, hindi pwede i-renew?
Ha?
I-renew?
Yun na yung revenue. Pwede rin siya revenue. Okay? Pero, during the validity of the patent or the copyright or trademark, pwede mo i-allow yung ibang tao na gamitin yan. Or, yes. Kasi right mo yan. You can exclude others, you can allow. No?
Parang yung franchising, sir. Parang magpa-franchise. Yung pag-aalaw.
Yes, but franchise is more on the business aspect. Iba na siya sa copyright, trademark, at patent. So yung franchise kasi, kumbaga yung right to sell specific product, kumbaga sa Jollibee, no? If you franchise Jollibee, okay, you have the right to sell or to distribute products of Jollibee. So iba yun sa patent, copyright, at trademark. Kasi yung itong tatlo, itong patents, these are all intellectual properties. Yung sa franchise kasi, that's a what or more of a business solution. Kumbaga. Bibenta mo na hindi lang yung product pati yung system ng accounting, system ng inventory, lahat na nandun na. Okay? So before yan, magte-train ka muna, ipapaaral mo sa yung system bago ma-approve ka na mag-franchise. So mas malugo yung franchise. Okay? So ganun siya. Although it's parang same na siya. Stringent requirements, the third purpose is stringent requirements seek to ensure that ideas in the public domain remain there for the few use. So ano yung sinasabi niyan? Stringent requirements. Ito yung dapat bago, involves inventive step, and industrially applicable. Kasi kung nag-exist yan dati, it must remain for public use. No? So hindi mo siya pwede i-patent. Hindi mo pwedeng sabihin, huwag kayong gumawa niyan kasi akin yan. Hindi mo pwedeng sabihin yun. Okay? It must involve an inventive step, and it must be for the benefit of the public. It must be industrially applicable. Okay? Questions? So, elements of patentable invention. Hindi innovation, ha? Okay, invention din. So, we have already paulit-ulit na to, asa na-take note nyo na or na-mark nyo na. Okay, so when we say new, we mean novelty. Must be novel. So dapat bago. If the device or process has been known or used by others prior to its invention or discovery, then the application for patent must be denied. So kung hindi siya novel, hindi siya bago, existing na siya dati, the application for patent must be denied. If granted, so kahit pag granted siya, it is void and ineffective. Okay? So, originality and precedence, in essence, it must be new to the world. Diba? Yung bago talaga. So, these times, mahirap na mag-introduce ng bago talaga. Diba? Meron ba kayo naisip na bago talaga? Diba? Parang halos lahat ng problem in any human field, parang halos lahat meron ng solution. No? Mahirap na yung wala pa. Kung meron kayong maisip, di ba? Why not? Di ba?
Actually, under patent din po ba yung mga product ng basta yung sa research by applied researches?
Saan? Parang...
Di ba po, kapag applied research po kasi kailangan po nila ng product na ginagamit po. Kasi ang head po nila is yung product mismo. So, iba-patent din po ba?
If that results in a new invention, kung pumasok siya dyan, ay kung pumasok siya dun sa elements. Diba? If it's new, if it's not created, walang process na na-involve siya, talagang bago siya, why not? Why pwede? No? Kung talagang wala pa nag-exist na gano'n, bakit hindi? Diba? As long as meron siya lahat ng elements of a patentable invention. Talagang bago siya. No? So, ang sabi din nito, It is the burden is on the person who averts it. So who averts? Novelty is the applicant. So ikaw na mag-apply for a patent, no, ipapapatent mo, ikaw ang mag-prove na bago yan. Diba? Sabihin mo dyan na, hindi pa yan nag-i-exist, bago yan. It's like, pero yung flying cars kasi meron na eh. Sa, ewan ko kung sa Dubai yun, o sa, yung mga, sa ibang bansa, meron na yun. Pero dito wala pa. Okay? So talagang bago. Yun yung novelty. Okay? So section 21 provides for non-patentable invention. So meron, yung discuss ko kanina are patentable invention. As long as they are new, involves inventive step, and industrially applicable, those are patentable. Pero ito, never mo mapapatent. Itong mga ito. So ano yung una? Discoveries, scientific theories, mathematical methods. No? You cannot patent those discoveries, scientific theories, and mathematical methods. No? Kasi discoveries, wala ka namang in-invent dyan. I-discover mo lang. Di ba? Scientific theories, wala ka namang na-invent dyan. Na-prove mo lang. Na-prove mo na tama yung scientific theory mo. Wala ka namang ginawa dyan. Wala ka namang product ng mind mo. Although, your mind is working on formulating a scientific theory, but that scientific theory has been existing. Okay, na-formulate mo lang o na-establish mo lang. As well as mathematical methods. So, those are already existing. Naiisip mo lang. Okay? And, in case of drugs and medicines, the mere discovery of a new form or new property of a known substance which does not result in the enhancement of known efficacy of that substance, or the mere discovery of a new property or new use for a known substance, or the mere use of a known process, unless such known process results in a new product that employs at least one reactants, hindi patentable ang drugs and medicines. No? So, saka lang siya magiging patentable if you can enhance its known efficacy or it results in at least one new reactant. Kasi itong mga ito, nandiyan na yan dati. Okay, wala tayong na-introduce na bago. For the purpose of this clause, salts, esters, ethers, polymorphs, yan, mga chemistry, shall be considered to be the same substance. So, pare-parehas lang daw yan. Salts, esters, ethers, pare-parehas lang daw yan. Okay? The second one, na hindi mo pwedeng i-patent is schemes, rules, and methods of performing mental acts, playing games, doing business, and programs for computers. So, hindi mo siya pwedeng i-patent. No? Let's say, for example, sa laro, naka-discover ko ng bagong move. Say, for example, sa basketball, no? Bagong move, o kaya bagong play. Lahat naman na maglalaro ng laro na yan, alam mo yun, parang may encounter nila yung play na yan, or yes, no? So hindi mo pwede i-clean off, ako ang unang umikot ko, diba? Hindi mo pwedeng sabihin yun, akin yun, note ko yun. Hindi mo pwedeng sabihin yun, no? Kasi they are part of the game as well as a business and programs for computers. Except lang siguro with regards to softwares na pwede mong i-license. No? Next, methods for treatment of the human or animal body. So, hindi mo din siya pwedeng i-patent. No? O, ako ang gumawa nito ha. I-opera mo itong throat, pero dito mo sa likod, niluksan. Pag dito mo sa likod, akin yan. Hindi mo pwedeng gawin mo yan. Hindi pwede.
Mabayad kapag ginawa mo.
Okay? Kasi, treatment yan of human or animal type. Okay? Plant varieties or animal breeds. Laws of nature na kasi ito, boss. Hindi mo naman pwedeng sabihin na pinag-mate mo yung dalawang breed. Yung kalabasan niya na akin yan, ha? Breed ko yan. Okay? So, hindi pwede yun. Or, kung plants, kung halaman man, no? The next one, aesthetic creations. Ano yung aesthetic creations? Umiram ka ng, ano kaya?
Yung nag-design na ano, sir, kunyari yung sa garland, kukuha siya ng bagong design.
Yes. Anything na pinaganda mo. Hindi mo pwede sabihin na, pwede ko i-patent yan. Kasi maganda na siya, hindi na siya. Kaya lang dati, no? Beauty is subjective, no? Beauty is subjective. To make something beautiful is subjective. And wala naman, kung pinaganda mo yung blackboard, di ba? Ano ang technical solution niyan? Ano ang problem na nasolve ng pagpaganda mo? Meron ba? May inventive step ka ba? Meron ba? Pwede siguro yung last, industrially applicable. Pero yung unang dalawa, baka sumablay ka rin. Anything which is contrary to public order or morality. So hindi ka pwedeng mag-invent something that promotes or that is contrary to public order or morality. No? This is with the exception naman of weapons. No? Siguro ang may lagay mo yung nuclear weapon or anything na against public order or morality. Okay? How about yung hindi, wag mo.
Tanong mo na, itanong mo na, sir.
Wag na. May mga bata dito. Sino mga teenager dito?
Ako, tingin pa ako.
Teenager na ba?
19 ko lang po.
19? Ang dami.
Karamihan ko sa akin
13. 13 na. Okay, sige. Huwag na natin discuss yun.
Oo nga, anak.
Baka makita mo sa Lazada, mo yun sa Lazada. Ay, talaga. Ito mga to, ha?
Anong klase ito yun?
Maganda. Huwag mo na itanong, di mo na
Okay.
maintindihan.
Guys, we are in a religious... Uy, i-upload ko yan too. Okay, section 23, novelty. So, an invention shall not be considered new. Hindi daw siya pwedeng masabing bago if it forms part of a prior art. So, what is prior art? It's defined by section 24. Una, everything which has been made available to the public anywhere in the world. So kahit wala dito sa Pilipinas, basta nagawa na siya sa ibang bansa, that is prior art. Before the filing date or the priority date of the application in the invention. Ngayon, very important to guys, lalaman din itong second. So itong second naman, the whole contents of an application for a patent, utility model, or industrial design registration filed or effective in the Philippines with the filing or priority date that is earlier than the filing or priority date of application. So this second paragraph talks about two applications. Okay, dalawang applications yan na dapat sa magkaibang inventor. Okay? That the applicant or inventor and inventable are not one and the same. Okay, yung sa second paragraph kasi, merong, what is date? Today is 28, tama? Okay. Let's say for example, Mr. A filed a patent application on 11/28 Mr. A. Okay? Pwede yan? Hindi naman. Thank you. Sabihin mo lang sila ng ano kayong invention? Basta may invent siya something, no? Ngayon, Mr. B filed on 11/29 bukas, okay, regarding the same invention, pero he is claiming for a priority. When one is claiming for a priority, lalo na kung sa ibang bansa yan, ibig sabihin, parang before pa siya nag-apply dito, existing na or nag-file na siya ng application sa ibang bansa. So, let's say for example, noong February pa. Noong February pa siya nag-file. So that is a priority. Ibig sabihin, magbibigyan ng priority si B kahit pa mas nauna si A nag-file dito sa Philippines. Ganon din dito naman sa una naman, okay, if meron ng gumagamit ng invention na yan before pa siya na-applyan ng patent application, okay, hindi na siya pwede maging new kasi prior art pa rin siya. Dito naman, nagiging prior art siya kasi ginagamit na siya before. Okay, so yan yung prior art na sinasabi natin. Gets ko ba? Gets ba? Yung una, okay lang, no? Yung pangalawa, okay lang din? Okay, so hindi siya pwedeng maging novel or bago kung existing na siya. Okay, yun lang yung simple explanation under novelty or prior art. Non-prejudicial disclosure. The disclosure of information contained during the application during the 12-month preceding the filing date or the priority date of the application shall not prejudice the applicant on the ground of lack of novelty. So meaning, say for example, the application date is today, the 12 months preceding. So, October, September, pababa. Kung let's say for example, yung una, the inventor made the disclosure, diba? Since ma-TikTok na tayo ngayon, i-TikTok niya na naka-inventor siya ng ganito at ganyan. Tapos, may nakapanood sa kanya na isang multi-billion company, ginaya yung invention niya, nakapag-file sila ng application nila ng 11/27, no? Let's say for example, nung May siya nag-TikTok, May 20, nag-TikTok siya. Nakapag-file lang siya ng 11/28. Okay? Itong May, pasok sa 12 months before November, tama? Tama. Ito, kaso lang naunahan siyang mag-file ng application ng multi-billion dollar company. Sino ang may right pa rin? Si original inventor. Okay? Kahit pa nauna si multi-billion dollar company. Yun yung sinasabi nating non-prejudicial disclosure. Basta yung information regarding dun sa patent, okay, is disclosed by the inventor. Gets? Kung sakali naman na hindi si inventor, sino ba? Kung yung patent office, yung IPO, okay, and the information was contained in another application filed by the inventor and should not have been disclosed. Pero na-disclose, di ba? Confidential information, pero na-disclose, okay? That will not prejudice the inventor. So kahit pa merong mamunang makapag-apply sa kanya, that is considered as non-prejudicial disclosure. or in an application filed without the knowledge or consent of the inventor by a third party which obtain the information directly or indirectly from the inventor. So, ultimately kay inventor din galing. Okay, whether directly or indirectly, it will not prejudice the inventor. So, kahit pa mauna silang mag-apply kaysa kay inventor, okay, it will not prejudice you. Okay? Third, a third party which obtain the information directly or indirectly from the inventor. Almost similar. Similar din sa D. Okay? Understood? Understood? Yes? For the purposes of subsection 25.1, inventor means any person what the filing date of application had the right to that patent. So, pag tinanong kaya kung anong ibig sabihin ng inventor, alam niyo ang ibig sabihin na any person who at the filing date of application had the right to the patent. Okay, that is the meaning of inventor. Next, inventive step. So, ano naman yung inventive step? An invention involves an inventive step if, having regard to prior art, it is not obvious to a person skilled in the art at the time of the filing date or prior date of the application claiming the invention. So, it means that if it pertains to a prior art, saka lang natin gagamitin yung inventive step. Ito na yung, kung babalikan mo yung original na definition ng ayan, no, ng patentable inventions, ito na yung improvement to the product or the process, meaning it is already existing. No? There is already a prior art. If there's already a prior art and you want to patent it, it must involve an inventive step. Okay? In case of drugs and medicine, same ito yung sa first, yung sa non-patentable inventions. No? Okay? Same to that. In case of drugs or medicines, there is no inventive step if it will not result in the enhancement of the efficacy or it does not result to at least one new reactant. So the same conditions for drugs and medicines. Okay, so yan yung inventive step. Industrial applicability naman, any invention that can be produced and used in an industry shall be industrially applicable. So it can be massively produced. Okay, that's why even if nakapag-invent tayo ng something that will solve one of the biggest problems of mankind, if hindi siya industrially applicable, hindi siya pwedeng i-produce on a large scale basis, hindi magbe-benefit ang tao, it is not patentable. Okay? So yun yung all about patent. Okay? The right to a patent naman, of course, the right to a patent belongs to the inventor. So kung sino yung, ano yung meaning ng inventor? The one who, a person who filed at the date of application, because siya yung may right dun sa patent. So, si inventor lang daw, pati si heirs are asides na, meaning yung direct na family na. Okay? Kapag dalawa naman, or madami ang nag-file ng patent, okay, they shall have unequal right, joint right or equal right on the patent. Okay, questions? None? First to file rule. If two or more persons have made the invention separately and independently of each other, the right to a patent shall belong to the person who filed an application for such invention. So itong first na phrase, okay, kung 2 or more daw ang nag-invent, kung sino yung mag-file ng application, siya yung may right. Paano kung yung isa hindi nag-file ng application? Diba? Eh, yung isa lang nag-file, siya daw ang may right. Okay? Pero kapag dalawa na sila nag-file, it belongs to the applicant who has the earliest filing date or earliest priority date. So that is what you call the first to file group. So kung 2 or more persons ang nag-invent ng same invention, the one who filed first his application shall be the one referred in the application of patent. Okay, the right to priority is not equivalent to patent kasi that can be contested. Okay? We're talking about application lang naman. No? Okay? So, let's proceed. Section 30. Inventions created pursuant to a commission. Of course, the person who commissions the work shall own the patent unless otherwise. Walang problema dito sa una. No? Kung sino yung nagbayad dun sa work, yung may-ari. Okay? Except if meron silang contract. No? Or, in case the employee made the invention in the course of his employment contract. May na-invento ka, pero nagawa mo yan in the course of your employment contract. What is the rule? The patent shall belong to the employee if the inventive activity is not a part of his duties. Even if the employee uses the time, facilities, and materials of the employee. Let's say, for example, sa isang company na ma-manufacture ng airplanes. Okay? Say for example, isang employee nakapag-invent na flying vehicle that only caters to one individual. Kung baka parang motor siya, pero lumilipad na motor pang isang tao lang. So naka-invent daw siya ng ganun, but this employee is what do you call that? Okay. Cleaning personnel. Siya isang cleaning personnel. So, does this invention belong to the company or to the employee? It belongs to the employee kasi
Hindi naman siya part ng
the employee is staff of the cleaning personnel. Therefore, the invention is not part of his regular activities. Kahit pa gamit niya yung oras, yung facilities at materials na employee. But, it belongs to the employer if the invention is the result of the performance of his regularly assigned duties. Kung part talaga yun ng trabaho niya. Okay? Di dapat kay employer yun. Pero, meron pa rin tayo provision na unless there is an agreement contrary to that provision. No? So, pwedeng kay employee pa rin kung meron silang contrary agreement. Right of priority, this one I have discussed na kanina. No? With regards to inventions from other countries, wala sa atin. No? Kung gusto magpa-register dito, they must claim for a priority deal. No? Kasi baka naman, matagal na yan na invention nila, pero ngayon lang nila ni-apply sa atin. Okay? Ang importante lang sa right of priority, ang mag-claim ng right of priority is an inventor in another country. Okay? Na gustong mag-apply for patent under the Philippine law. Gets? Yes? Gets? Doon, yun lang ibig sabihin ng right of priority guys ha. Priority kasi taga-ibang bansa siya, baka earlier niya lang na nagagamit yung invention niya. Kaya meron siyang right of priority. Hindi ito pwede exercise ng Pilipino. Okay? Kailangan yung inventor is from another country. Gets? Gets?
Ito sa previous na section, sir, yung letter B po. Yes, sir. What if si employee po na-invent niya yung bagay, during din po dun sa regular, or yung regularly assigned duty niya, then nung na-invent niya na nag-decide siyang mag-resign, then sa kanya po pinapatent. May claim po ba doon sa patent? Pwede po bang kontrahin
Under this same circumstance?
like, pinapatent niya lang po nung nag-resign na siya.
Pwede.
Pero na-invent niya po during yung regular course.
Actually, habulin yan ng company. Habulin yan. And kapag employed ka sa mga ganun, masyado kasi matatalino na yung mga taong nandiyan sa mga companies na yan. Usually, meron silang may non-compete clause sila sa employment nila. Usually, hindi ka pwedeng pumasok sa other companies having the same business, having the same granting na galing ka doon, hindi ka pwedeng mag-engage sa kanila. Meron sila usually ganyan clause. No? And hindi ka rin pwede mag-start ng sarili mong business na employing what you learn from that company. Within a year, ang usual na provision dyan is 1 year, non-compete. Bawal kang makipag-compete sa kanila for 1 year. That is valid. Okay. Why? Because it is an agreement between two parties. And yung sinasabi mo na invent ka, tapos nag-resign siya, tapos papatent mo, makikita din nila yan. Lalo na company sila engage in creating that or inventing those particular inventions. Magiging aware sila dyan. And may involve ka lang sa lawsuit kapag sa ganyan. Kakaso ka lang. Ganyan usually sa ibang bansa, kaya meron ding right of priority. Okay? Kasi minsan, nag-uunahan. No, lalo na kung mayroong nakalik na information or makuha mo lang yung parang layout o yung blueprint ng isang invention, and kaya nilang basahin yan, kaya nilang gayahin, pwede ka nilang unahan mag-apply ng patent. Okay? Ganun lang usually sa mga business world na. No? Pero sa mga normal na buhay ng tao, hindi mo naman, it's not relevant. Okay?
Sir, may tanong po. Paano po pag kunwari buildings, yung kunwari bago siya, bago yung design ka na siya, hindi bang impact?
Yung industrial design.
Hindi siya pwede mas labor experience.
Industrial design, pwede siyang pumasok sa industrial design. Pwede. Pwede siyang pumasok. Okay? So those, that is on your patents. So let's proceed now on trademarks. So the functions of trademarks, it indicates origin or ownership of the articles to which they are attached. Of course, diba, if you see the logo of Apple, you see the logo of Samsung, you know kung saan sila galing, you know kung ano yung standard nila, just like it says in the second function, it guarantees that those articles come up to a certain standard of quality. Diba? Kaya minsan, gusto mo ng branded, kahit na parehas lang sila ng in-offer, diba? Branded na shoes, branded na pantalon, diba? Kasi alam mo na, kapag yan ang binili mo, quality. Diba? Kasi sabi, Lalo na yung mga enthusiasts or yung talagang loyal sa kanilang mga brands. Diba? Apple yung watch, Apple yung cellphone, yung AirPods, at yung damit. May damit ba na Apple? Bili ka dyan sa sa ukay?
Yung mga tawag-tawag ng
Okay, so yun, no? Yung mga loyal sa mga brands, no? Kasi they know that these products, they are of a certain standard of quality. That's why most of these products then is pricey compared to other regular products. They advertise the articles, they symbolize. Diba, imagine, carry mo lang yung Apple mo na cellphone. You are advertising. Diba? The fact that you're using it, diba? That's advertisement. Hindi nyo lang alam yun. Diba? Yung gamit mo na Adidas, kitang-kita na Adidas yung may tatlong stripes, or yung Nike.
May
That is,
tawag po ata dun sa advertisement, type na advertisement na gano'n. Yung parang ginagawa ng tao without them knowing.
yes, that's free advertisement. Diba? 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 You imagine, you're just walking, ikaw na pala nagpo-promote sa Nike, sa Adidas, di ba? So that is, those are the functions of a trademark, no? Para mag-mark yung company. So mark means any visible sign capable of distinguishing the goods, trademark or services or service mark of an enterprise and shall include the stamp or mark container of goods. When we say collective mark naman, it means any visible sign designated as such in the application for registration and capable of distinguishing the origin or any other common characteristic including the quality of the goods or services of different enterprises which uses the sign under the control of the registered owner of the collective mark. The trade name naman, it means the name or designation identifying or distinguishing an enterprise. So ibang trademark na mark sa trade name. Ang name is pangalan na business. Say for example, ano yung example natin?
Apple.
Yung meron kasi noon, merong Mang Inasal. Diba? Tapos meron yung okay hotdog. Inasal, yung inasal niya parang sa inasal ng inasal. So, i-discuss ko naman, meron siyang picture mo mo.
May nabasa ko meme sa Facebook. Parang isusuata siya ng Starbucks kasi yung nila, yung designs ganun nung logo. Tapos sinabi po nung gumawa na like meme daw po niya yung ginamit. Starbucks po ito yung meme. Tapos mukha.
Parehas din yung logo.
Tapos yung sa mukha, sir, mukha niya yung nilagay niya. Tapos, sabi dun, hindi daw po ata nila hindi po ata pwedeng mas ng Starbucks yung lalaki.
Pero wala pang decision.
Hindi sir, meme lang ata yun sir.
May meme lang.
Hindi pa
Meme lang.
nabasa ng maayos.
Kapag logos kasi, mark yan or trademark. Okay? Kapag yung name mismo, yung name ng company mismo, trademark. Pwede rin nagkaroon ng infringement doon. Okay, i-discuss natin dito sa trademark. Dito sa trademark kasi madaming infringement na nangyayari. I think aware na kayo dun sa iba. Ito. Ayan, di ba? Gin Capital in Ginebra. Ayan. You have San Miguel paint pencil and Guinevere paint pencil.
Parehas. Wow, very authentic naman.
Ito yung sobra. ito sa noong 2018 lang ito or 2019 sa China. Sa China ito. Joy will be ano. Tapos yung products nila the same.
What if umorder sa Jollibee para inventa nila?
That is infringement, guys. Ha? Kaya siya ginagaya kasi may name, alam niyo yung goodwill sa accounting? May goodwill na siya, di ba? Meron nga. May reputation na siya sa tao. Di ba? Kagayahin mo siya kasi akala nila mamaya, Jollibee ito. Di ba? Bibili naman sila. Yung Pilipino naman, nakita lang yung mukha ni Jollibee. How marks are acquired? The rights in the mark shall be acquired through registration. So your trademarks should be registered in the Intellectual Property Office. Your trade name, you can register that sa DTI, Department of Trade and Industry. Doon mo makikita kung meron kang kaparehas na trade name. Makita mo na siya kasi doon kaagad. Okay? A certificate of registration of a mark once issued constitute prima facie evidence of the validity of the registration of the registrant's ownership of the mark and the registrant's exclusive right to use the trademark. The applicant is required to submit a declaration of actual use of the mark with evidence within 3 years from the filing of the application. So pag nag-register ka for a trademark, within 3 years, kailangan na naman i-submit na declaration of actual use. Meaning, ginagamit mo talaga yung trademark na yan sa products mo, sa services mo. Okay? And you must show proof or evidence that you are indeed using that mark or that trade name. No? So yun yung how marks are acquired. Registrability. So, ano yung hindi mo pwedeng ma-trademark? Okay? A mark cannot be registered if it consists of immoral, deceptive, or scandalous matter which may disparage or falsely suggest a connection with persons, living or dead, institutions, beliefs, or national symbols, or bring them into contempt or disrepute. Nakakita na ba kayo ng trademark na ganyan? Hindi pa ako tapos ha.
Hindi ako kayo, sir.
Hindi pa ako tapos, nag-react na kayo, di ba?
Sino yun?
Ikaw kaya.
Hindi, si Rochelle yun.
Immoral, deceptive, or scandalous matter. No? Or those may falsely suggest a connection with living or dead persons, di ba? Tayo ka na, ano ka ng trademark na may mukha si President Digong, President Marcos, si Arroyo, di ba? Si Aquino, di ba? You cannot make them as trademark. Okay? Consists, pero may exemption dito, we'll discuss later. Consists of the flag or coat of arms or other insignia of the Philippines, so, or any of its political subdivisions or any foreign nation. So hindi pwedeng maggawa ka ng trademark or logo ng isang company na mayroong flag ng Philippines or flag ng kahit anong countries. Or gamit yung logo ng AFP, ng BFP, or ng kahit anong government agency.
General, bawal mak-mak.
Bawal ma?
Mak.
Ano ma?
Mak-mak. Parang mantres. Mantres, pinawala din ang sa gamit.
Ba't ka mag-mak? Bawal kang mag-infringe. The proper term is infringe. O yung gayahin. Diba? Pag mag kasi may intention ka na. Diba? Tawa. Kung magmamak ka lang, hindi mo na ipaparegister kasi baka mahuli ka pa. Diba? Kasi bawal din ang paggamit ng flag for any other purposes. Diba? Kaya siya flag ng Philippines kasi kung baka dapat you treat that flag with respect. Okay? Consists of name, portrait, or signature identifying a particular living individual except if it is with his written consent or the name, signature, or portrait of a deceased president of the Philippines during the life of his widow except by his or her written consent. So pwede, hindi pwede generally. Okay? signature, name, or portrait of a deceased President of the Philippines. Except kung may consent daw ang asawa, kung buhay pa. Okay? Or kahit na sino man nang wala siyang consent. So if meron siyang consent, walang problema. Ang hirap kasi dyan is you will later on identify this portrait, signature, or name to a certain product. No? Eh dati siyang presidente, tapos ngayon, gagawa ka ng product out of that, gusto mong ilagay yung mukha niya doon. Siyempre, titignan mo rin kung gusto niya rin na mahihilala siya as doon sa product na ipopromote mo. So under trademark, madaming confusions, madami din kaso ng infringement. So, ang usually na ginagamit ng Supreme Court is likelihood of confusion or colorable imitation. So what does it mean when we say there is a colorable imitation? Kumbaga may pagkahawig, may pagkaparehas yung dalawang mark. Sabi dito, such a close or ingenious imitation as to be calculated to deceive ordinary purchasers or such resemblance of the infringing mark to the original as to deceive an ordinary purchaser, giving such attention as a purchaser usually gives, and to cause him to purchase the one supposing it to be the other. Kung mahirapan yung purchaser mo na i-distinguish kung anong product yun, kung sa'yo ba talaga or sa kabilang company, no? It means that there may be a colorable imitation. No? Kasi nga, mark mo yan eh. Gaya ng McDo, ng Jollibee, ng Nike, ng Adidas, hindi ka mahihirapan na tingnan sila kasi pag nakita mo na yung check na yun, kay Nike yun, yung tatlong stripes na yun, kay Adidas yun, di ba? So, ganoon yun. Kung mahihirapan sila, ibig sabihin, Nike na toothbrush? Meron bang Nike na toothbrush? Wala. Baka meron ha. Kasi may Nike na cologne. Meron mo? Cologne, di ba?
Yung ano na lang ang sabi na, yung sa Jordan. Ang dahil po kasi infringement, pero yung sa logo nila ay nakabend yung paano yung isa. Yung isang paa.
Meme yan. Okay? May mga gano'n, di ba?
Tapos yung Adidas.
Adidas.
Yung Adidas yung wala.
If you become, more aware of the laws of the Philippines, you will become aware na madaming batas na hindi sinusunod. And all because we want to treat the person better. Sabihin mo, kawawa naman sila. Wala silang ibang hanap buhay. But what they are doing is wrong. No? And we can keep saying those words. Kasi there are laws in place. There are laws that needs to be followed. No? Kung maging strict lang tayo, kung wala yung mga recent enactments, una na lang sa mga bicycles. Bicycles are not allowed to use the road. Do you know that? You don't know that. The trucks, yung mga trucks na ang gulong nila is yung malapad, tapos yung patusok-tusok, yung mga ganon. They are not allowed to use the road. Do you know that?
Ay, sir, yung mga tricycle po ba dito sa Tuguegarao na like makapal yung usok, pwede pa rin ba yun dito? Kasi sa kawayan, sir, hindi ko.
Bawal.
Bawal na?
Yes,
Bawal
sir.
naman talaga yun.
But then, marami tayo nakakasibago.
Because of the implementation. It's not the laws that is the problem. It's the people. Kasi when you talk to the people, lalo na dun sa mga law enforcement agencies, di ba? Yung iba, nagpapabayad. Yung iba, hindi ka mag-anak yan, ganito. Hindi, kung yan. Sinabi na kasi, anak siya ni Mayor, ba't mo pa uliin? That's the reality. And if you are going to to implement it strictly, ikaw pang magiging
Sama.
that's the reality. That's why it's on you guys later on if you become professionals or whatever it is that you might advocate, you must always advocate for the good. You can allow yourself to be used as weapons, no? Para mas lalong maging corrupt ang isang agency. Lalo na kayo, you are CPAs. Future CPAs. Soon to be CPAs. Most of the time, sa isang workplace, matalino kayo. Most of the time, kayo ang makakaintindi kahit ng mga batas. Why? Kasi pinag-aralan nyo. Alam nyo kung paano umintindi ng batas. Kahit pa paano nalaman nyo. And most of the time, kayo rin yung aabuso. Look at BIR. A lot of CPAs. Let's continue. Ay, bukas pala, bukas. Let's continue tomorrow.
Thank you, sir.
Pa-assist naman sa ano.
Ay, short lang yung fire.